Hi, my name is Michael Jones. I'm a volunteer attorney with the Veterans Legal Institute in Orange County, California. In my military life, I'm a judge advocate with the United States Army. In my civilian life, I'm a certified bankruptcy specialist and national CLE instructor on bankruptcy matters. This information pertained in this video is designed to be general in nature, and while I am an attorney, I am not your attorney. In order for you to obtain legal advice specific to your particular circumstances, you're advised to consult with an attorney of your own and let them guide you through the process. The bankruptcy system is extraordinarily complex, and as such, the individual factors in your case may make a significant difference as to the best route to pursue. An attorney, by far, is the best way to advise you in how to handle that situation. If you are an attorney representing someone in a bankruptcy case, it's important that you choose the right path of the bankruptcy case for that particular individual. As such, for you, we'll talk about what the types of bankruptcy chapters are and the types of circumstances they're designed to deal with. We'll also talk about the components of the case, what's necessary to prepare the various documents in filing the case, the typical timeline from the practitioner's standpoint, and the benefit of a discharge, as well as what you do if a creditor violates the discharge injunction. The first thing we're going to talk about are some of the things that need to be considered before you pull the trigger on a bankruptcy filing. Again, this is extraordinarily important because once a bankruptcy case has been filed, it generally cannot be dismissed at will by the debtor. As such, you want to make absolutely certain that this is the right course of action for you to pursue. Some of the things that need to be considered are the fundamental purpose of a bankruptcy case. What is it that we're trying to accomplish of this area of law? Generally speaking, a bankruptcy case is filed and becomes what's called an order for relief at the time it is filed. Once the case is filed, it is time-stamped to the minute, which is very important because something goes into effect that radically affects the financial life of the debtor upon filing, and that is the institution of the automatic stay. The automatic stay prohibits creditors from taking any collection activity against the debtor. This is vitally important if you're trying to stop something that's going to otherwise occur and cause financial ruin to the debtor. For example, the filing of a bankruptcy case will stop a foreclosure proceeding. The filing of a bankruptcy case will stop a repossession of an automobile. It'll stop a garnishment running against wages of the debtor. It will stop a lawsuit. All of these things go into effect the minute the case is filed. The bankruptcy code is divided into chapters, and each chapter has a particular purpose or goal in mind. The two chapters that are most important for the typical veteran filer will be Chapter 7 and Chapter 13. A Chapter 7 case is what's called a liquidation case. The goal behind a Chapter 7 case is to take the property of the debtor that's not exempt, more on that in a moment, sell that property to get a big pile of money, take that money and pay creditors as much as you can, and whatever the creditors get is all they get. Any balance that's still remaining due to that creditor is simply wiped out. And when we wipe out debt in a bankruptcy case, we call that a discharge. The other chapter that's usually the only other one appropriate for a veteran filer is a Chapter 13 case. A Chapter 13 case is not a liquidation case. Instead, the idea is that an individual pays their debts as they are able on an ongoing basis, such as their rent, their car payments, food, groceries, utilities, things like that. And then the money that's left over from their budget after that is paid to a Chapter 13 trustee who distributes those funds to creditors over the life of a plan. A Chapter 13 plan is typically 36 to 60 months in length, and at the conclusion of that plan, the individual obtains his discharge. There are other chapters of the bankruptcy code, but they are not usually applicable to the typical veteran file. There's Chapter 12, that relates to farmers and fishermen. We have both of those in Orange County. There's also Chapter 11 that is largely used for commercial filers or business filers, but they can be used in the instances of a consumer as well. Now, one thing that you must keep in mind in determining the chapter of the bankruptcy case is whether you are eligible under that chapter. In order to file a Chapter 7 case, there are limitations on your income. If an individual's income is too high, they'll have to file a Chapter 13 or a Chapter 11 or 12 case. In a Chapter 13 case, there are limits on debt. If you are over the debt limits for a Chapter 13 case and over the income limits for a Chapter 7 case, you will have to file a Chapter 11. A Chapter 11 case is vastly complex and is beyond the scope of this video. So next we're going to talk about the various pieces and components of a typical bankruptcy case. There's terminology that's used throughout the case, and it's important that you understand what these are. The first concept that is used in a bankruptcy case, or term that's commonly used, is the debtor. The debtor is the individual who is filing the bankruptcy case themselves. It's not meant to be derogatory in nature, it's just what we call the guy. We also have creditors in the case. The creditors are people who are owed money by the debtor. There's also another individual called the trustee. The trustee's job is to gather up all of the assets of the debtor that are not exempt, use that property to pay the debts of the debtor as much as they can, and then close out the case. In cases where there are no assets to be distributed to creditors, the trustee's role changes. He merely becomes the face of the system. He'll be the individual that you meet with after the case is filed. He'll swear you in under oath. Do you promise to tell the truth? And then at that point, he will ask a series of questions that typically amount to variations of, did you read your paperwork and is it all true and correct? In order to understand the trustee's role, it's important that you understand what is meant by exempt property. Property is merely a bankruptcy term that refers to the stuff owned by the debtor. It can be tangible or intangible, meaning it can be things that we can touch and hold, or it can refer to rights, such as the right to bring a lawsuit against another individual. When you file a bankruptcy case, all of your property becomes subject to administration under the Bankruptcy Code, unless it is exempt. The reason why property is exempt is because if we took all of a debtor's property away from them, they would literally have nothing. They would be standing naked in the street because they would have lost their clothes and everything. That doesn't allow for a person to receive a fresh financial start because nobody's going to want to hire a naked person standing in the street. So Congress allows all people to maintain a certain level of property. And that property that you're always allowed to keep is called exempt property. In California, we have two different sets of exemptions that you can choose from, but you must use one or the other. You cannot mix and match between the two various exemption schedules. The first of these exemption schedules is called CCP 703, referring to the California Civil Code of Procedure, and these exemptions are largely designed to protect property for non-real estate owners. If you use the 703 exemption, they're generous enough that for most filers in Orange County, we are able to exempt all of their property. The 704 series of exemptions are largely designed to protect equity in real estate. We can protect about $600,000 of equity in real estate. Now that's just the equity we're concerned with. So if the debt that is attached to real estate exceeds the fair market value, you don't have to use 704 exemptions. You can use the 703 exemptions because there is no exposed equity to deal with. The next area that we want to talk about is a little bit more detail of the various chapters of the bankruptcy case. The Bankruptcy Code is contained in Title 11 of the United States Code. It's broken down into chapters. Each of these chapters has a particular purpose or goal in mind. A Chapter 7 case, the liquidation case, is designed to quickly administer the assets of the estate and allow for the debtor to receive a discharge as soon as possible. It largely amounts to a debtor somewhat pushing all of his property across the table to the trustee, letting the trustee deal with that property as he chooses, and then simply going forward with his financial life from there. A typical case where no assets are administered might take about 4 months from the beginning to the end. However, it is extraordinarily important that you not file a Chapter 7 case unless you are certain that the debtor will not lose property they are not willing to lose. The next chapter that most veterans would consider is a Chapter 13 case. We used to call this a wage earner plan. In these cases, no property is sold from the debtor. So if the debtor is not able to exempt all of their property and they don't want to lose their property, this is the chapter debtor would want to pursue. It is also in Chapter 13 cases that a debtor can catch up past due payments on secured loans, such as car loans or home mortgages. So if a typical veteran is simply behind on his house payments and wants to catch those up, a Chapter 13 is usually the chapter they would pursue. The same would be true if they've gotten behind on their car payments and they want to catch those back up. Again, a Chapter 13 is the right chapter typically to pursue. A Chapter 7 case will not be the proper vehicle to catch up past due payments on secured loans. There are various things that can be accomplished in a Chapter 13 case that simply cannot be done in a Chapter 7 case, such as reducing the amount of debt secured against collateral, such as a car loan, to the fair market value of the collateral. Now, in a Chapter 13 case, you can only do that with a car if the car loan is more than about 2.5 years old, 910 days. But at that point, you can reduce the balance of that loan. This becomes very effective in instances where an individual is upside down on the car loan to a very large amount, making a Chapter 13 an excellent choice to be able to reduce their financial liabilities. If you are a bankruptcy practitioner preparing a case for a veteran, there are varieties of software packages that you can use to prepare the case. Now, a bankruptcy case is very complicated with numerous files and components all pieced together to form the entire case. So that you understand the terminology, the petition itself is only about the first 5 or 6 pages of a bankruptcy filing. After that, there are numerous supporting schedules where more detail is given concerning the debtor's debts and his assets. Each of those schedules cover a particular component of the debtor's financial life. For example, Schedule A and B is where you list all of the property of the debtor. If you're a bankruptcy practitioner, it is very important that the debtor understand that property is just a bankruptcy term to refer to the things owned or controlled by the debtor. It is not just real estate. Very often debtors will say, I don't own any property, but they always do. Even their clothing would be property. So make sure that they understand they need to be thorough and complete. The Schedule B breaks down the individual assets that are owned by the debtor in great detail, covering things such as their clothing. Even their pets are listed specifically in Schedule B. Schedule A is where the real estate holdings are found. Schedule C is where the exemptions are listed for the debtor. This should be, in most cases, a complete matchup to all of the assets. In other words, you should be able to go through Schedule A and B, list the value of that property, and then fully exempt it on Schedule C. Schedule D is where we begin listing the debts of the debtor. Schedule D deals with the secured debts of the debtor, such as car loans or mortgages. Schedule E are priority debts that may cover things such as recent tax debt and things of that nature. Schedule F is where we list what is commonly thought of as our debts. These are general unsecured debts. This is where you would list credit card debt, medical bills, student loan debt, loans that you've taken, such as payday loans or signature loans, all of these things are typically general unsecured debt listed on Schedule F. The bankruptcy petition also includes another series of forms where we list our income and expenses. Schedule I is where we list our income. The debtor will need to provide all of their income information for the last 6 full months so that you can calculate what their average income is to put on Schedule I. Schedule J is where the expenses are listed for the debtor. That would cover their housing expense, their food, insurance. Nearly everything that the debtor spends will be specifically broken out on Schedule J. Now, if you're considering a Chapter 13 filing, be aware that Schedule I then will show us what our average income is. Schedule J will show us what our average expenses are, and the difference between those two, sometimes called an I and J differential, is the amount of surplus funds that will be used to pay the Chapter 13 plan over the 36 to 60 months of the plan. There are 1 or 2 other forms that are also contained within a bankruptcy petition that are not schedules, but still provide important information to the court and to the creditors. The Statement of Financial Affairs, called a SOFA commonly, S-O-F-A, contains a variety of other financial information that are not just summarized up with a basic number. These will include things such as whether the debtor is involved in any lawsuits currently, or whether anyone has repossessed property of the debtor. It also allows an opportunity to explain why property may have been lost, such as through gambling, fire, theft, or other disasters. Next, we want to talk about what a typical timeline is like for a bankruptcy filing. Now, there are 2 things that you need to keep in mind when you go to file the case itself. The first is that there is a requirement before a consumer case is filed that the debtor take a consumer credit counseling course. The consumer credit counseling course is not optional and must be done before the case is filed. There are a variety of resources available on the internet to take these courses, and you're welcome to use any of them. Candidly, the information contained in a consumer credit counseling course is of very little value to a debtor. By the time a typical individual is considering a bankruptcy filing, they're far past the stage that information will help them. However, after the bankruptcy case is filed, another document must also be obtained, and that's the financial management course. The financial management course, unlike the credit counseling course, does have beneficial value to most consumer bankruptcy filers. When the bankruptcy case is filed, the filing itself is time-stamped by the court clerk to the minute. When that case is filed, the automatic stay goes into effect. The automatic stay prohibits creditors from taking any collection activity against the debtor. It's very important that you realize the automatic stay can be violated by creditors who do not yet know that a bankruptcy case has been filed. But the bankruptcy automatic stay is effective against acts of creditors whether they know about the filing or not. The reason why that is important is any activity that violates the automatic stay is automatically void. To give you an example of how this works in real life, if an individual is expecting a foreclosure of their real estate at 9 o'clock in the morning, and a debtor files his bankruptcy petition at 8:59, 1 minute before that occurs, the automatic stay goes into effect at 8:59, and if the foreclosure goes ahead anyway at 9 o'clock, it is automatically void. This enables the debtor's financial affairs to remain on hold and static to allow things to be orderly administered in the bankruptcy case. This is why you must consider the timing of your bankruptcy case too. Whereas it does immediately stop everything, you generally want to file your case in as comfortable of a window as possible to allow you to give these types of creditors notice so that they don't go through with collection activity anyway. Although the collection activity will not be effective against the debtor, it can complicate the case. When the case is filed, about 30 days after the filing of the case, there will occur an event called a creditor meeting, sometimes known as a 341 meeting. 341 refers to the section of the bankruptcy code that covers these creditor meetings. While we call it a creditor meeting, that's largely a misnomer because creditors rarely come. Instead, what will happen is the debtor will meet with the trustee. The trustee will swear the debtor in under oath. Do you swear to tell the truth? Yes, I do. And then after that point, the trustee will ask a series of questions that largely amount to variations of, did you read your paperwork and is it all true and correct? The typical questions will be, did you read your paperwork? Yes. Did you sign the paperwork under oath? Yes. Did you list all of your property? Yes. Did you list all of your debts? Yes. Are there any changes or omissions that need to be corrected? Now at this point, if you have realized that you did accidentally leave something out, at that point you would point that out to the trustee and say, I forgot to list this creditor or I forgot to list this property. The trustee will ask you to amend your petition to correct the paperwork and then continue on. A typical Chapter 7 no asset 341 meeting lasts approximately 2 minutes, 120 seconds. Whereas most debtors are very anxious about it, it's really a fairly brief and informal type event. You are able to watch other 341s if you want to see what they're like before yours comes up. In a Chapter 13 case, the 341 proceeds the same way as it would in a Chapter 7 case, except in a Chapter 7 case, the trustee is looking for property that they might be able to administer. In a Chapter 13 case, the trustee is going to want to make sure that you have enough income available to fund the plan that you are proposing to pay your creditors over the 36 to 60 month period of time. Now remember, creditors can come to your 341, and if they do, they're welcome to ask you any questions concerning your income, your assets, your debts, or other aspects of the case. It's rare for a creditor to attend a 341, but they can and do come. To give you an idea of how common they occur, you might see a creditor show up at a 341 meeting maybe a few times a month. And that's for not just my cases, but for everybody's cases. They're unusual, but again, they do happen. After the 341 is completed, there's a window of time for creditors to file an objection to your discharge. It's 60 days from the first meeting of the creditors. During that period of time, a creditor can object to you receiving a discharge of your debts. In general, objections to discharge are based on misconduct. You've done something wrong. It can either be misconduct related to a particular debt, such as you vandalized someone's property, you beat them up, you stole from them, things like that. Or it can be misconduct related to your case in general, such as you're hiding property, you're really a closet millionaire, but you don't want anybody to know, things of that nature. A discharge objection to your whole case will prevent any of your debt being discharged. If it's a particular creditor who alleges misconduct concerning their debt, only that debt of that particular creditor would be subject to not being discharged. If no objections to discharge are made within the 60-day window allowed after the creditor meeting, in a Chapter 7 case, through an automated computerized process, the court will enter your discharge order, and then shortly after that, your case will close. Now, a discharge order does not list each particular debt and then state that it's discharged. It merely says all of your debt eligible for a discharge is discharged. In a Chapter 13 case, after the 341 has concluded, there will be a time where a court hearing will take place. Now, unlike a Chapter 7 case, in a Chapter 13 case, you do actually see a judge. The judge in a Chapter 13 case will evaluate your plan to determine whether or not you have met all the legal requirements in order to confirm the plan. If so, the plan will be confirmed by the court, and the debtor from this point will provide a monthly payment to the Chapter 13 trustee. The Chapter 13 trustee will then disperse that payment out to creditors as is described and set forth in your Chapter 13 plan. That process will continue for 36 to 60 months. At the end of that plan, then you go back to court, advise the court that you have fulfilled the obligations of your plan, and you will obtain your discharge. Now, whether it's a Chapter 7 or a Chapter 13, you must complete your financial management course before the discharge can be entered. It's my recommendation that all debtors complete their financial management course before they go to their 341. The reason why is because if you don't, you'll forget. And if you forget, you will not get your discharge, and the entire case will largely have been a waste of time. There is another possibility that can occur, and that is that a creditor does object to your discharge. If that happens, it takes place through what's called an adversary proceeding. They're commonly known as an AP in a bankruptcy case. It's a small lawsuit that takes place inside the bankruptcy case itself. If there is bankruptcy litigation going in a case, that is outside the scope of this video, and I would highly encourage you to confer with a bankruptcy litigation attorney. The last thing that we want to talk about is the discharge. Once the discharge is entered in a bankruptcy case, the debtor has essentially crossed the finish line. One distinction that you should be aware of is that a discharge does not say that a debtor is not allowed to pay his debts. It merely says a creditor can never ask them to do so. Sometimes a debtor may choose to pay a debt that has been discharged of their own free will, either because of a moral reason of their own or in order to keep an asset that is secured by a lien. A discharge does forgive the debtor's personal liability against the debt, but the creditor may still recover that debt against an asset that has secured it. Let me explain to you what that means. If a debtor has a car loan and the discharge is entered, the creditor cannot go to that debtor and ask them to pay that car loan. But if they don't pay that car loan, the creditor can foreclose against that car and take that through repossession. So, even though the debt has been forgiven, the creditor would, or the debtor rather, would want to continue making the payments on that car so that they can keep the asset. A bankruptcy discharge order acts as an injunction by the court, meaning that it is a court order that prohibits creditors from taking action against the debtor. If a creditor violates the discharge injunction and takes collection activity anyway, court involvement is usually necessary. For example, a creditor, even after being discharged of their debt, may file suit on that, or what's more common, give that debt to a collection agency, and the collection agency tries to collect that debt. Each of these instances violate the discharge injunction. In those cases, you would appeal to the court for damages to be awarded to the debtor based on that violation of the discharge injunction. This is a litigation matter, and as such, you should confer with an attorney who's skilled at doing bankruptcy litigation if a discharge injunction should occur. A discharge injunction also acts to void any judgment to the extent that it creates a personal liability on the debtor, but it does not discharge the liability of third parties. most commonly guarantors of the debtor's debt. To give you again an example of what this means, if an individual has signed a personal loan and then they are discharged of that loan, but the person's parents guaranteed that loan, the creditor can still go to those parents and demand that they pay that full debt. There's a substantial amount of law on the subject related to third-party discharges, and generally speaking, again, you are not going to be able to obtain relief from a third party. There are exceptions to that, although they typically involve married individuals where one party files a bankruptcy case and the other does not. California is a community property state, and as a result of that, the non-filing spouse does receive benefit from the discharge of the filing spouse. But this is a complex area of bankruptcy law that should be carefully reviewed by an attorney. There are some exceptions to the discharge that are definitely worth noting. The most common exception to a discharge is student loan debt. With very few exceptions, student loan debt is not eligible for a discharge. Another type of debt that is not typically eligible for a discharge is recent tax debt. The general rule is that tax debt that is less than 3 years old is not eligible to be discharged in a bankruptcy case. However, old taxes typically are. There are requirements that are necessary in order for older tax debt to be met. You'll need to make sure that those requirements have been fulfilled if the purpose of your bankruptcy case is to seek a discharge of old tax debt. Typically, it requires that the tax year be more than 3 years old, that the debtor have actually filed a tax return, and that the assessment from the IRS is not very recent. If these criteria are met, the tax debt is typically dischargeable, whether it be owed to the state of California or if it is owed to the federal government. There are other forms of debt that are also exempted from discharge, but they require litigation in order for a creditor to keep it from occurring. Individual misconduct related to a particular debt, such as debt incurred through fraud or theft or vandalism and things of that nature, a creditor can seek that debt to not be discharged, but it does require the creditor act by seeking a court order eliminating that discharge within the requisite period of time. Realistically, most creditors do not seek to accept discharges. Largely, the only time creditors do that is if the amount involved is substantial. Otherwise, it's simply usually not worth the creditor's expense in seeking to prevent the discharge. If you are a bankruptcy practitioner and you're helping an individual with a bankruptcy case, although student loans are accepted from discharge, you can seek intervention from the court to allow a discharge in your particular debtor's case. The standard to do this is very onerous. It is extraordinarily difficult to obtain a discharge of student loan debt. The reason why is because the circumstances that make it untenable for the debtor to repay that debt have to be such that they will remain in place throughout the entire repayment period of the debt. And that essentially is the lifetime of the debtor. As such, the most common ways in which student loan debts can be eliminated and discharged is if there is a catastrophic health event from the debtor. If the debtor has had a catastrophic event that renders them disabled and unlikely to ever return to work again, these are the types of cases where student loan discharge can often be obtained. In order to do that, it does require an adversary proceeding to be filed. This is a true litigation event. Once an adversary proceeding seeking the discharge of student loan debt is filed, it runs as a regular federal lawsuit within the bankruptcy system. The burden of proof is on the debtor to establish that he should receive a discharge of that debt. These cases can be complicated and they are involved, and I would encourage you to confer with a bankruptcy litigation counsel before you embark down that road. If you are an attorney here in the Orange County area and you're interested in doing bankruptcy work to assist a veteran, it gives you the opportunity to work with an organization such as the Veterans Legal Institute to help you through that process. They can pair you up with a veteran who is in a position of financial need to where a bankruptcy case may make a life-changing difference to that individual. It gives you an opportunity to help that service member overcome a real legal challenge in their life, and they will almost certainly be very appreciative of the help that you provide. I would encourage you to contact a Veterans Institute representative to talk to them about the possibility of working together with them to help a veteran who's in need.